The final frame of the 36-second video shows father and son each holding a firearm standing in the street, with Ahmaud Arbery laying on the ground, dying.
And of course, it came out that Travis actually uttered a racial epithet as standing over the body of Ahmaud Arbery. Okay, joining me to discuss is criminal defense attorney, former prosecutor, and University of Georgia law professor Titus Nichols, plus criminal defense attorney and former prosecutor Mazi Mazanou. Do you think it makes a difference if the defense now put on notice by the judge that they go out and find evidence that suggests this was the guy, or this was the guy that they had heard had possibly been doing the burglaries, which was clearly not the case, but if that's what they heard, would it make a difference?
No, the citizen's arrest requires that you actually see someone committing the crime before you engage in pursuit. And even then, it can only be done to detain them until law enforcement comes. Here, they did not know what he was doing. They did not have any definitive evidence to know that he had committed any type of crime beforehand. What they saw was a black man who they didn't recognize in their neighborhood. So they jumped in the back of their pickup truck like Dukes of Hazzard and went chasing after him with firearms. And this is what led to his death. The video itself really does show the flaw in the criminal justice system, and the fact that two prosecutors were aware of this video, yet it took the public release of the video before law enforcement took action.
Titus, let me ask you about that aspect of the case. Okay, you're following this guy. Now, we don't see everything on that video. Apparently, there was stuff that happened before the video started to roll where he was being boxed in by the cars. Will that help in terms of the prosecution's case and combating this idea that it was a self-defense case for Travis and Greg McMichael?
It absolutely will help the state's case, because defense is going to say, well, we just want to talk with them. Well, why do you need a shotgun to go talk to somebody? Why do you need to bring two of your friends if you want to go talk to somebody? Why do you need to box somebody in with two vehicles if you just want to talk to somebody? The idea that they just want to have a casual conversation is completely made nonsensical when you see everything else in the video. They all were armed. They used their vehicles to block him in. And then when Mr. Arbery tried to run in the different direction to get away from Travis, began to engage Mr. Arbery. So if they simply wanted to talk to him, they could have just simply came to him unarmed, or they could have done what other people would have done in that situation. Call the police and let trained law enforcement officers deal with the situation. But instead, they decided to take the matters into their own hands, and this is why we're in this situation.
But Titus, just quickly, the reason they're going to say they had to get guns, and this was brought out during the bond hearing, is that Travis McMichael had a gun stolen from his car. He made the logical leap that this was the guy doing all these things that were going on in the neighborhood as far as burglaries and stealing things. And he also said that when Bryan had approached him at another time, Travis had approached him at another time, he seemed to go into his pants as if he had a weapon, setting the stage for this idea that he felt in his mind he was approaching an armed person or a potentially armed person. How does that play in?
So there's two problems with that. Number one, Travis has no evidence that Mr. Arbery was the person that stole his gun, or was the person who had encountered Roddy previously before. So all you have is, I see a black man, I had a problem with a black man in the past, let me get a gun and confront this random black man that I see. It doesn't work out. You can't just say, well, I was justified because he looked like somebody who might have done something to me in the past.
So Titus, can you possibly make that argument? And will a lot of that, whether you make that argument, rely on who you get as a jury?
Well, let's take race out of it for a second. Let's say that it was three black men who had cornered Mr. Arbery and had approached him with guns. Any reasonable person would still make the decision that I'm going to fight for my life. These people have guns. I don't know why they're stopping me. All I know is this person who's close to me has a shotgun. I'm not going to sit here and simply beg him to let me go. I'm going to fight to get away. So Mr. Arbery was completely in his right to try to defend himself because of the fact that he sees three strangers, two of which have guns in their hands, trying to stop him. And the fact that they would not simply let him just go away, that gives him the reason he needs to fight for his survival. If I were the defense, how would we respond to that argument? As defense, you would simply say, well, we didn't have anything pointed at Mr. Arbery. We simply wanted to talk with him. And he became aggressive, and I thought he was going to try to take my gun. Honestly, the only argument that defense could make to say that they were just simply reacting to Mr. Arbery is the argument that, well, once he grabbed my shotgun, I didn't know what he was going to do with it. I had to defend myself.
Will it matter who jurors are in terms of how they look at it?
It is going to matter. If you have a juror who believes that a citizen has the right to take the law into their own hands and that a citizen has the right to detain somebody because they think they might have committed a crime, that juror might be more inclined to believe that the McMichels were defending themselves. Now, there's really no way the prosecution can know that when they're doing jury selection, because every juror who raises their hand says that they swear to be impartial and listen to all the evidence. But no juror can put aside their own lived experiences or outside experiences when they sit in that jury box.
You told your husband that you thought it was a bad idea for Mario to be called as part of this bond hearing. Why is that?
Because I was worried about with the threats that I got and the harassment our friends have had, that with his job, that he may lose his job.
Again, that was the wife of Gregory McMichael, Allison McMichael, on cross-examination by the prosecutor. All right, let's talk more about what happened and what we saw in court over the last couple of days. Now, Titus, how do you feel that's going to affect the case? He's exactly right. Mozzie said there's going to be a change. Joyette Holmes was actually voted out by the voters. There'll be another DA coming into this case. How do you think that will end up affecting how the case is tried, or won't it at all?
Well, it's all going to come down to whether Jesse remains in the office. As is traditional, when there's a new administration, some of the senior people make a decision as to whether to stay or to leave. The incoming DA has never prosecuted a felony, so he can't prosecute the case. He has to trust one of his deputies to do it. And with Jesse being in the office, if Jesse decides to move on to somewhere else, they'll need to find someone else who's highly capable, highly experienced to handle such a complex case.
I think one of the things that the defense was arguing was the health of Gregory McMichael. Could that be possibly affected?
The defense is doing it because they want to curry favor, and they also want to present the picture that the defendant is ill and it's going to be a burden on taxpayer resources to have to pay for his medical treatment. The problem is, in the age of COVID, lots of defendants have made that same argument, and their bonds have all been denied based upon being released for COVID. So if the judge is not willing to do that for any other defendant, it's unlikely that they'll do it for this defendant unless they can show something significant, such as the necessity for very specialized, very expensive medical treatment that the jail is unable to provide by itself.
Titus, how do you think William Bryan plays into this? Is there a chance that he might end up turning state's evidence, may decide to testify against them? He's already made some statements that I believe have hurt them. I don't think he did that purposefully. I think it was inadvertent. I think he was just telling his version of the truth. But how do you think he might end up playing out in this case?
Well, we won't know until an actual trial date is set. In my experience, especially when you're dealing with multiple defendants, nobody wants to cooperate until they actually see the white of the jury's eyes. But in regards to Roddy, he is more likely to cooperate than a father and son is. With the father and son, you can almost assure that they're not going to say or do anything that hurts the other one, whereas Roddy doesn't have that familial connection with them. Now, it's unknown if he's willing to do that. He might very well say, I'm going to hitch my wagon to the other two people, and I'm going to argue that I didn't pull the trigger, that I didn't shoot anybody, and I didn't have anything to do with it. So it could go either way. It really just depends on how much evidence they have to show that Roddy was a willing participant versus he was just there with the camera and then saw what happened after the fact.
The judge said, they showed in the video how they might respond to any problems or anything that comes up. So I thought it was an interesting choice by the judge, an interesting choice of words by the judge. Titus?
Absolutely. I mean, and then the issue you also have is the fact that, as the judge put it, they're safer inside the jail than out. Because if they're granted bond, there's going to be the issue of their safety. There's going to be people who are very supportive and very angry. And then you run into the issue of, are they going to stay in their home or are they going to leave? Are they going to flee the jurisdiction? It goes back to the issue of the judge wants to ensure that they are present for their trial whenever it happens. Now, another issue is the COVID. No one knows when trials are going to safely be conducted. While yes, judges are now saying that they're putting plans in place, we don't know because no court in Georgia has actually put on a physical trial with these new COVID restrictions. So we don't know how long they're going to be sitting in pretrial confinement.
Titus, I want to thank you so much for joining us. You're fantastic as always, and I'm sure you'll be joining us again sometime soon.